Thank you. Thank you, Toby. I do apologize. I'm really snotty and sniffly today. It's autumn is here, so my body's like, great, wear jumpers and have tissues next to you all the time. So I'm gonna talk through kind of everything that you can expect now post action, and we're gonna just go through kind of like a timeline. If you have any questions, you can pop them in the chat while I'm talking and I can pick those up first, or then after we go into the Q&A, you can ask them as Toby said in the beginning. So from actions, you've now been, you've gotten arrested maybe several times. From each arrest, you would have been released under different conditions. So you might have been RUI'd, which means released under investigation. If you have been RUI'd, the police can technically investigate you for as long as they want. There isn't actually a time limit for it. However, usually 6 months is the limit, because then at 6 months, there is a review that a superintendent will do to review the case. And if they can't argue that they will find more evidence and whatnot, they'll have to close the case, and they will inform you of this. If they don't, after 6 months, you can always ask them for this information, because you should get a letter to your house saying that, investigations, like they've decided not to charge you with the offense. You might have also been released with bail. So bail will give you 28 days. We'll give the police 28 days before they need to charge you, or then do a NFA, which is no further action. So with this, the bail can differ with police bail. So it can be that you've been invited to a bail meeting. This meeting is normally just you going to the police station, them taking you to one of those interview rooms, and them giving you some papers saying you have been charged with section 14, blah, 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 or no further action papers. That's it. So that basically the meeting that you would have is just them deciding or telling you if they are going to charge you or if they're not going to charge you. Sometimes they might also attach an interview to this bail meeting. It's not very common for them to attach an interview. It would only happen if they didn't interview you during your arrest process while you were in custody, and they've decided that by interviewing they would get a lot more information. Doesn't normally happen. They should always inform you before if they will interview you. And if they haven't informed you before, you can always deny the interview and say that you want to talk to a solicitor first, so you get more time. Then they basically just give you another date when they interview you. With police interviews, you can decide, any solicitor would probably tell you, just go with a no comment interview. I would recommend that as well if you don't feel comfortable giving interviews to the police without incriminating yourself or someone else. But also, why not use that interview as a place to state your piece why you're taking action? Because that will then, if you are later on charged, it will have to be shown either to the jury or to the judge. And you can do this in a very respectful and beautiful manner, as I know all of you are capable of, because I've just seen the actions and it's been, amazing how you, everything about it. I was very tearful when I was looking at what you're doing. Anyways, I'm getting off topic. So yes, you can decide to do interviews that way as well. But remember that they need to inform you that you're going to be interviewed if you have a bail meeting. And if they don't, you don't have to accept to be interviewed. So that's kind of that police bail thing. Breaching that bail meeting or not going to it is in itself a criminal offense. But what it would trigger is them likely coming to arrest you, usually at your own front door. So they'd come to your house, they'd arrest you there, then they'd give you a new date to attend the police station, and then they'd release you. So they wouldn't normally actually take you to custody, but it's just a bit of a faff. However, there are police officers who just want to make it really, really inconvenient. They would arrest you at an awful time of the night. So they might come at like 3 a.m., take you to custody, give you a new date, and then release you at 5 a.m. So sometimes they might just make it really inconvenient for you. And that's why I don't recommend missing the bail meeting with the police, just because it will just cause like inconvenience, and the police might be real, dicks about it. We know how they're like. But anyway, so breaching police bail itself is not a criminal offense. So you can't be charged for not attending or kind of breaking any conditions that they give you. Sometimes your bail conditions with the police may be that you are not allowed to enter a certain area. You're not allowed to go, let's say a dairy distribution center. That could be one. Again, if you do go and you're arrested there, it's not a criminal offense, but it would normally just trigger a process of the police probably investigating you, or the police informing the CPS, or the Crown Prosecution Service, that you're not compliant. So the CPS would have more reason to charge you and basically build a case against you. But itself, it's not a criminal offense. However, if you break court bail, so if you have a court date and you do not attend, that's called failure to surrender, and that is a criminal offense. So if you don't attend court when you've been told to go to court, that will always pretty much get an arrest warrant, and you may be remanded until the next court date. This obviously, all of these will depend on your own history with the courts and the police. Usually missing one date doesn't cause you to go on remand. But for example, Josh, who has been in prison since July, he is getting out in February because he missed 6 court dates. And he hasn't been given the right to appeal this decision. So, that could happen if you don't attend court. However, the police, just inconvenience you if you don't go. Then if you are charged, whether it is at the police meeting or that bail meeting, or then if you're charged by receiving a letter at home, there's, depending on what that charge is, depends how you can submit your plea. Usually it will come as a letter to your house, and it will, if you have the right to submit your plea by post, it will say it on that letter. Normally it will give you a date, and that date will be at a magistrate's court, and that magistrate's court is where you would submit your plea if you don't do it by post. Postal pleas can normally only be guilty pleas. So if you plead guilty and it's a lower level offense, so let's say willful obstruction, for example, you can submit that by post. I'm going to go into guilty and not guilty and why I don't actually recommend postal pleas all that often. But anyway, so from submitting your plea, going into court, your first plea hearing, it's a very simple hearing. You would stand in the little stall, and they would ask your name, your birthday, your address, and then the defense, they would confirm, the prosecution would say, you're here because you're charged with X offense at X place on this date. And the judge would ask, how do you plead? And you can say guilty or not guilty. If you say guilty and it is a lower level fine where it's just in the magistrates, basically then you would usually be asked to give a mitigation statement. So you can kind of put out your reasons for doing it, who you are, kind of a a statement about who you are as a character and your financial circumstances as well, to kind of mitigate whatever sentence the judge would then give you. That would basically be it. The judge would sentence you, or if there are several cases, the judge may order a pre-sentencing report, which basically just means that you won't be sentenced now for this offence because you have a lot of other charges coming up. So you'll be sentenced for those as like kind of like a bundle. So they're all bundled up together. So at your very last plea hearing or trial, whichever it may be, you would then be sentenced for all of these as just like one lump sum. So from this, like what you are going to say at your plea hearing, if you get charged and you are thinking of guilty or not guilty, I like to think that none of us are criminals. We're here to try and save the planet. So why should we say that we're guilty? We're not guilty of anything else other than trying to limit suffering on a beautiful planet, which is currently being destroyed. So why should we ever say that, yes, I plead guilty for something? So that's why I would always say, go not guilty, because we're not guilty of criminal offenses. Like, however, there are plus sides to pleading guilty. It kind of gets the thing done. If you plead guilty, the process is really short. That's kind of it. The plea hearing will be kind of like the final event for that charge, and that's it. So if you have a lot of other stuff coming up and you really can't spend your energy, your time, your money, like going to court, preparing defenses and so on, plead guilty. If it doesn't make you feel wrong, or if it actually helps you in the state where you are in, plead guilty. There's nothing wrong with it. Because as long as we know inside that we're not guilty of anything else other than trying to do the right thing, but yeah, so that's kind of the plus side of pleading guilty. Usually you would get a lower penalty if you submit a guilty plea. This is basically because, well, their resources are really, really short. So they're basically trying to get people to plead guilty so they don't have to go through the whole process of creating a really strong case against you, having solicitors and lawyers working on it, having a barrister in the court to then prepare, and then having judges or jury and judges working and sitting in a room and basically using up money that the judiciary and like the legal system doesn't really have. So they normally try and give you a discount for your penalty if you do an early guilty plea. An early guilty plea discount should usually be 1/3 of that penalty that you would have been given if you were found guilty after trial. However, this doesn't always really translate into what we see in penalties, because what really affects whatever your sentence will be is, as absurd as it sounds, but is what the judge had for breakfast that day, if they got laid the night before, if they were stuck in traffic for too long that morning. So you're going to be sentenced by someone who will have their own opinions, and they will state that they're only applying the law. But for most protest offences, sentencing guidelines don't really even exist. So there is kind of a big ballpark where the judge can just throw that somewhere according to how they feel. And really, that's why I also just say, why not go not guilty and really make your case? Because then, particularly if you're going to self-rep, which I'm going to come to in a little bit, you will be able to talk about the necessity of your actions, the proportionality of your actions, your right to protest, and all other arguments that you can come up and have ready. And you can actually tell your truth to that judge or a jury if it's a Crown Court case. So a lot of the times what we've now seen is that when all of that is actually laid out there, the penalty has been lower than for those who've just pled guilty, because, even though they do, they submit their mitigation statement and they may read this out loud in front of the judge. The mitigation, it can only really take about 5 minutes. But if you are going through a trial, you have at least an hour, maybe 2, to actually make your case and trying to prove that you're not guilty. So that's why I would what I would balance with the guilty and not guilty. Then going into as well, the actual trial, the trials, they're not as scary as they seem. There isn't that whole objection whole thing that doesn't exist. The judges do wear wigs, which I just kind of find funny. But usually it's not that scary. Normally the judges are also quite nice. And especially, they do try and make sure that you understand the whole process. That's kind of their job as well. So you can ask if there was something that, for example, you didn't hear, because now also they've added glass boxes to a lot of the places where they didn't before COVID have glass boxes, but they didn't add microphones. So yeah, their audio systems are sometimes really terrible. So you might not always hear what the judge says. And if you just be clear about it and so on, they'll be really nice and accommodate. If you really want to know what happens at trials, there are a lot of trials coming up where a lot of brave rebels and activists are. So there are a lot of court support groups which you can go, and you can actually, all of these trials are public, so you can go and see how what happens. There's, especially if you are London based, there are so many trials in the Crown Court and also different magistrates around London. So, highly recommend just going and supporting a fellow activist and just seeing how that whole process works. A lot of people have chosen now to self-rep. Self-repping is, you'd be referred to as unrepresented, or LIP, so litigation in person. And this is basically a form of you being able to talk about what you did, how you felt, without having a solicitor or a barrister speak for you. I'm not saying that solicitors and barristers aren't great. There are so many who are absolutely amazing at what they do. But there is, obviously, when it comes to any sort of trial, the human factor of you speaking your own truth and someone hearing you speak your own truth, that might just be so much more effective, especially, if in let's say Crown Court trials, where there's a lot more process that goes on before an actual trial, a lot of legal defenses might be completely struck out. So there's a whole pre-trial hearings and management hearings and so on, where a lot of legal defenses, what barristers would be really good at laying out, if they're struck out, the barrister basically will just say, well, defendant felt this way, but wouldn't it feel a lot more honest and truthful if you, the defendant, said, this is how I felt, and you're saying it rather than the barrister? So that's, again, something that just have a think about it. We've got CASP does run weekly self-rep awareness sessions where we kind of just have very experienced self-reppers kind of talk through what the experience is like. And then we've got training courses for it. So it's like a three session training course. So if the time comes and you want to self-rep or you want to look into what it could be like, there are lots of resources for that. And yeah, we've got training sessions for that. So don't be scared. You won't be just pushed out there into the room. and just have to stand there, the only person without a wig in the room. So then going into kind of the costs, obviously, of all of this. Cost can be, it very much depends, again, on the judge, what they will make you pay at the end. Usually what we see in magistrates, so if you're unfamiliar with how the courts are laid, there's magistrates, which is the lowest level of courts, you know, from very like small level offences, and most protest offences will be at magistrates. Then you've got Crown Court, which is one step higher, and at the Crown Court, that's the level where you would have a jury who would decide if you're guilty or acquitted. And then above that, there's the High Courts of Justice and Supreme Court and so on, but we rarely get to those. So magistrates, the cost always stay obviously lower at the magistrates than the Crown Court. Magistrates, usually you would have a victim surcharge, which would be around £75. That's just like a very common thing that we see. I don't really know where this number comes from, because and who the victim is usually, but this is like a very common one for protest cases. I think almost everyone in Insular Britain who had willful obstruction, they got 75 or 50 to 75 pound victim surcharge. So this is basically an additional cost on top of a fine that you could get as the penalty. Then usually you would get around £200 as legal cost if it's a very short kind of like 2-hour trial, or then if it's a magistrate's trial that takes longer, it could be up to around £800 for the legal costs. Obviously, you don't have to pay any of these if you're found not guilty, or if you're acquitted or the case is dismissed. Then you don't obviously have to pay for anything. This is only if you're found guilty, and the judge will make the decision as well how much of this you will pay. And a lot of this will as well come to if you've done a mitigation statement that asserts your financial status. They don't normally want to basically make you incapable of living you know, your normal life if you get any kind of legal costs or fines. There's always a possibility to organize a payment plan as well. So don't worry, you don't have to pay it all as a lump sum. Even if sometimes the judge would want to kind of scare you and say, I'm not going to allow a payment plan for this, they will, and the judge doesn't actually decide. You will call another number and there will be a nice lady usually on the phone. And if that first lady isn't nice, you call again the next day and there will be someone else on the phone and they'll sort out a payment plan. So you don't actually have to pay all your fines and your cost in one go. I think the lowest payment plan that I've now heard of is £3 a month. And I think it was for about 5 years, I think, that they're doing that. So, and then there's our famous Biff, who's doing £5 a month for 83 years. And inflation isn't taken into consideration in these. So basically, he's going to be giving pennies in 83 years. So there's all these like different ways of not actually having to suffer with those fines. Then going to Crown Court, where the costs are obviously higher, depending on what the outcome obviously of the trial is. Usually Crown Court cost, if you've been self-repping and you're not paying for a solicitor and a barrister, it would be in the thousands, usually from around £1,000 to £6,000. That obviously, again, depends largely on how long the trial is. So it's really difficult to give proper estimates. If it's a really long and difficult trial, it could be 10K for the legal cost. But this is not something that we usually see. And again, most times people aren't actually ordered to pay that whole sum. And a lot of the times as well, the judge will see that if the legal costs are really high, they don't actually give you a fine. They just keep that legal cost as the fine, if that makes sense. So that becomes your penalty, just paying for the legal cost of the whole situation. Then if you do want representation, and not even representation in court, but you would like to have legal counsel before, or if you've got a really tricky case and you think that there was police misconduct during your arrest or any of the investigation process, definitely get some legal counsel from a protest experienced law firm like HJA, ITN, Binman's, or Bird's, or Kelly's. And you can, if you qualify for legal aid, I will put legal aid forms in the chat in a bit. But if you qualify for legal aid, I think it's, don't quote me on the exact amount, what the limit is that you can make in a year, but I think it's around like 22, 23K. So if your income is below that and you don't have assets of more than £50,000, I believe, then you can qualify for legal aid. I think those are the numbers. And also, if you're a student, you will automatically qualify, or if you're on state pension, you will automatically qualify. Legal aid doesn't, so not every lawyer wants to work on legal aid as well. So you will have to make sure that that lawyer and the barrister are okay to work on legal aid, because legal aid doesn't actually pay them a living wage. So it doesn't always necessarily mean that you will find a barrister and a solicitor to work on legal aid. However, if you really want representation, and for example, right now, barristers are striking because of the whole legal aid situation and them not getting paid, your case will be adjourned, so will be pushed back for as long as you can find representation for. So if you clearly state that you want representation and there is no one to represent you and no barristers working, it will be adjourned and you will get more time. So don't worry, you won't be forced into self-repping if you really don't want to self-rep. On legal aid as well, if you want legal counsel, but you're thinking about self-repping, so you want kind of a lawyer to look at your case before you actually go to trial or go and state your plea, don't tell any solicitor saying, I'm on legal aid, I want you to look at my case, but then I want to self-rep, because they are not allowed to then accept you as a legal aid client. You will have to tell them kind of that you're indecisive about self-repping. Most of them know now that that means that you will drop them and self-rep, but that means that they can also, with their good lawyer hearts, follow the law and the rules about how to accept legal aid clients, and they can also budget their work so that they'll do all the work and kind of get paid still before the trial, and then you'd drop them right before the trial or right before the plea hearing. So that's basically about legal aid. Then going to kind of the last section, which is anything to do with your property or any sort of police misconduct. So we're working closely with Netpol to report any sort of police protest abuse, and we have an email address which I will just pop in the chat now. There we go. So that one, send us anything that happened if you think the police acted in an unlawful way, or if anything was done in your custody, you weren't given your meds, you were misgendered, you were anything that the police or custody sergeants or CPS, if they do anything that you believe is unlawful or inhumane, send us an email. We don't create civil claims, but I can definitely help you out creating a civil claim if you want to actually take action against the police. don't think that taking action against the police will lead to a remedy or even an apology. Usually it doesn't. Sometimes it might lead to kind of like a thank you, we'll make note of this. And very rare occasions they'll actually do something about it and give you compensation. Most times they do come up with some sort of lies and excuses for why they behaved or, you know, punched you in the face or whatever they did. So just don't enter the process thinking that that will be a resolution for anything that happened. I'm not saying that you shouldn't complain and make sure that every police misconduct is reported. So don't be quiet about it. Please do come forward and, you know, email protest abuse. Or then if you want to make a claim, I can help you out with that. It is quite simple. You do it directly to the police force that it's about. And just, if anything happened, try and note it down in as much detail as possible. Keep that on, like, hold on to it. If you got any injuries, have a GP look at them and report them and tell the GP where it came from, so that can also be reported and actually noted. And I had something else, but it just left my mind. That's fine. It might come back, it might not. Then about your property, if any of your property was broken, you can do the same. You can complain to the police force. Any sort of, if they, let's say, smashed your phone or broke your camera or anything like that, usually those ones you might get some like money compensation if you make a claim and you have, you know, receipts and you have proof that it was them and so on. So you can do claims against any lost property or damaged property as well. Then how you can get your property back if it's been seized during any investigation or arrests. This would happen, or they would automatically return it to you. Well, that's kind of what they should do. They should automatically return it to you at the end of all investigations or at the end of any court proceedings or trials. So they should automatically do it. We often see that they kind of lose a few bits on the way. So do just kind of keep emailing them. You can call them. It should be always at the police station where you were arrested, where that whatever property is should be stored. And then if it was during a raid, you should be informed where anything is stored and when you would get it back and which police force is in charge of storing it. So if you weren't informed, let's say they took your laptop during a raid and you weren't informed, or you don't know what they took if you weren't home when they raided, that is unlawful, and they should always give you a very detailed list of everything that has been taken. So again, that would go directly to the police force who was handling the raid or the arrest when any property was taken. Yes, okay. I think that's pretty much everything that I had planned to talk through. We can go to questions, and I can just do the ones in the chat first, and then anyone who wants to ask questions on the video, you can turn your video off, or you can show your face to the recording, and you can ask them that way. If you put your, like, you know, the hand emoji reaction on Zoom, that puts you in like order at the top. There we go. There's first person ask keen. So then we can go in order. And yeah, we'll kind of finish up with the questions a few minutes before 7. So then we can have a nice grounding, because I do appreciate some of this is quite like heavy stuff, and it can sound really scary. And you know, you've done the hardest part already. Hardest part is taking action and, like, you know, stepping up and doing that. And this, it feels really like emotionless and numbing and can feel really scary and overwhelming. Don't worry, we can, like, even if you just don't even want to open your letters that come from the police, you can literally just take a photo of them and and I can translate it in normal talk to you. So, you know, everything, you're going to be supported throughout everything. So don't worry. Okay, so I'm going to do the questions from the chat. Yes, so explain the agreement between Animal Rebellion and HJA. There's basically, it's called access to justice, and that basically it's set prices for set bit of work, and they basically agreed to take Animal Rebellion activists during this whatever happens into their books and help you through. And if you're not qualified for legal aid, with that agreement you can get better prices for the work. And also what I recommend is, if you're with, let's say you were part of an action where you threw loads of paint on a big bell tower, for example, and all of you, let's say 5 of you who were there, all get charged, and 2 of you qualify for legal aid, you can get HJA to work. They're very happy to do this and like bundle you up and basically do the case and the preparation for all of you, because it's basically just repetition, and only use the legal aid to cover all of that work. We can also then, if you, as an action group, all of you get charged or some of you get charged, we can then always hold group Zooms with HJA and with CASP and have kind of that kind of question time with HJA or with just CASP and so on. So you can kind of go through the whole process with those people from the action that we're charged with you. Because normally also your plea dates and any trial or anything, that would be the same. So you would actually go through the whole process with the group that you took part in action. They're nice like that, aren't they? They keep us all together. And so I hope, did that answer the question about the agreement between Animal Rebellion and HJA? So, then after how long can you start chasing them up to return your stuff? It depends if you were bailed, or if you were RUI'd, or if you have been charged. If you have been charged and there is a trial coming or a plea hearing coming, if that piece of stuff isn't actually direct evidence for a trial, you should get it back before. However, if they're going to use that as part of evidence in the proceedings, then you would get it back after all the proceedings. If you weren't charged and you were released with NFA, which is no further action, then you should get it back straight away and you could start chasing them up straight away. If you were bailed, it's a good thing to ask if you have your bail meeting and you go to the police station. It's a good place to ask for any stuff that's missing. They sometimes will say that it's part of the investigation, but you can always kind of challenge that in a gentle way, being like, oh, my jacket, really? Like, because you could just say, you can take a picture of me wearing it, I want my jacket back. So yeah, it depends on what the actual situation is of your case. If you need a solicitor for a bail interview, what will that cost you? I believe the amount for that is around £190, I believe. Don't quote me on the exact amount, but I think that's what I remember seeing. So 190, I think. Is there any likelihood that the police will cancel the initial bail meeting? Yes, there is. Actually, it's really good practice just to kind of call them a few times before the bail meeting and just be like, is it still on? Because sometimes they will say, oh, we cancelled it and we did send you a letter. No, they didn't. They just want you to make that really awful journey to a random police station in Barking or somewhere, and then they'll be like, why are you here? So yes, there is a very high chance that they would actually cancel the bail meeting and they wouldn't inform you. So do call them. And can the police extend your 28-day bail hearing for a later date? If so, how long for? They can extend it. I can't exactly remember the amount of days they can extend it, but usually they'll have to have really solid reasons why. And that could be, for example, that you're not in the country, and you explain this to them, and they could push it back. Or then, you've got, I don't know, cancer treatment. I don't know what could be. But usually they wouldn't push it back. They would want to get it done in that 28 days because it's just a lot more paperwork for them to try and apply for a new date. So usually it would be in that 28 days. And with a minor, will the parents be asked to fund legal costs? That is a very good question. It depends on the age. Usually the parents wouldn't be asked to fund any legal costs. Under 18s will always qualify directly for legal aid. I don't think I said that actually. So they would be covered partly by legal aid. And usually what courts try and do for any minors, they wouldn't like to give too high of fines and cost and so on, because that, if you what can under 18s earn, what, £6 an hour? It's going to take them a lot longer to pay anything off. So usually under 18s will definitely be treated with a bit more of a gentle hand in any proceedings. And that also comes to the costs as well. I can't remember exactly what the age limit is where the parents are obliged to fund some of the legal costs. I don't think 16 and 17-year-olds, I don't believe the parents are obliged to fund them. I will have to check that, but I think that's basically after you can legally work, your parents are not obliged to fund your costs. That's kind of the logic behind it. And then one of my bail dates has already been extended by another 2 months. Is this legal? I thought it had to be 28 days from arrest. It is legal, but they've just done a lot of paperwork to get that done. There would normally be a reason that they've found, either they're grouping things together, or that's part of the investigation. But yeah, I would probably just get in touch with them and see if that's something that they're doing. Oh dear, there's so many new messages. Okay, I'm trying to be quicker, and then we do video questions and then back. Okay, would being a part-time OU student be automatic qualification for legal aid? I didn't get to speak to a solicitor at all. Do I have any comeback? Part-time student, I don't think you qualify automatically, but you might still qualify. And if you didn't get to speak to a solicitor at all, that's completely fine. Most people in custody don't actually speak to solicitors. So don't worry, it's completely fine if you didn't get to speak to a solicitor. If you weren't interviewed, don't really think there is ever a need to even speak to a solicitor. And if you've been arrested a few times and you know how to go through the interview process, I don't ever speak to a solicitor when I'm in custody, and most people actually don't. It's a lot of work for the solicitors for basically telling you to just say no comment the whole time. So that's basically that. The only thing that a solicitor is, I think, very, very useful for during interviews is that if they then give you bail conditions, which are really, really strict, solicitors have a way of debating the officers in a very kind, gentle manner to get those bail conditions a bit more lax. So that's kind of the good side of having a solicitor with you. And then, should I be using the same solicitor that I had during the original arrest interview? You don't have to. If you want to, that is completely fine. Usually that the solicitor who you had in the original arrest interview, they might be assigned to your case. If you go, for example, if it was someone from HJA, and then you're going to ask for them to represent you in any proceedings, usually they would be assigned to your case automatically because they were there for the interview. If not, it's because they don't have any capacity, and that's fine. They do share all the information. I would recommend having it from the same law firm, so HJA most likely. If you want to take action against the police and sue them, is it better to go through a solicitor than complain directly? Are there any firms you can recommend who specialize in police misconduct and do no win, no fee? There are a few companies which I can recommend. We've also just recently got a new member in our legal team at CASP who's specialized in civil litigations with actions against the police. So I will definitely get her to do like I'm like assigning jobs here for now, but I'm going to get her to kind of do a guide in how to do this, because I've actually never worked on civil litigation like that, but she is specialized in that and works at a law firm doing that currently. So I will definitely make sure that that resource is shared. I'm gonna say that I'm gonna put all the any firms that I think of in that resource, which will be shared with Animal Rebellion. I'll make sure it is, just because I can't think of them at the top of my head right now. I hope that's okay. Okay. I'm not sure if I can afford to travel to the police stations for these upcoming bail meetings. Is there any financial support I can receive for this from the police or whoever? The police won't pay for it. A lot of the times, if you kind of address this with the police beforehand, they might cancel the meeting. Or then if you really need support for this, CASP does have financial support, which you know, we're trying to support everyone financially as much as we can, and for that, you know, we just ask you to share our fundraiser or a crowdfunder with you know, your wealthy family members and friends, and then we can support you with your travel costs and so on. So you can email CASP about that, and we can see if we can support you at least a little bit if the police decide to still have you come to the bail meeting in person. Then when getting booked into arrest, the station asked a list of questions: name, address, nationality. Am I obliged to answer any of these? Will there be a disadvantage in denying answers to them? So what you're legally required to answer is only your name, your address, and your date of birth. Don't tell your nationality, because they only collect data. Don't tell your job, they only collect data. You know, these kind of things, they're only collecting profiles of activists. That's what they're doing. The only ones that you need to say is always your name, your address, and your date of birth. If you don't say those, the only thing that's going to happen is that they're going to take you in front of a magistrate before a magistrate in the next day or two. So you'd just be in custody for longer. But again, it's not a criminal offence not giving your information to the police. And the information is stored by the station and on the national policing computer. Their home office has access to them, but only if the information is flagged. So only if there's any sort of worries that the police sergeant, head person, high up in the police, if they think that there's something to flag about your case, then they'll flag it, and then they'll kind of, that will be visible for the home office, and I believe border control as well. I'm going to now jump into the video questions, because I see that there's 4 hands who've been waiting very patiently. I think we're going to overrun a little bit because, you know, and there's still so many questions in the chat. No, there aren't. There's 2 more. Okay, I'm going to do video questions and then I'll finish the chat questions and then we do a grounding. Yes? Perfect. All right. Tequila. Hello.
Yeah. Thank you so much, Lex. That was amazing, very valuable. I actually have 3 questions, if that's okay. But I'm gonna try my best to not take too much of your time. But so my questions are very much oriented about like us being international. So I'm here on behalf of several people who have come from basically like 1,000 miles away, and we have like 3 different dates for the police station meetings. And so my first question would be, like, we're not going to be there, right? Like, we already know that. We just can't make it for several different reasons, be it financial or like work related. So what's the worst thing that can happen to us if we're supposed to be there, if it doesn't get canceled, we can't make it, and then, for example, we show up in the UK next year? Like, can they, check our passport and be like, oh, there's something here, let's take your stuff, let's take you to the police station or something like that? Like, what's the worst that can happen to us, and which steps should we be taking?
Yes, so that definitely, I would try and get the meetings cancelled, because what the meeting basically is them just charging you or releasing you without charge. I would try and get them cancelled. That would be the first thing. If you can't cancel them, you could let them know that you won't be there. And what they would do is put an arrest warrant on you. And that would definitely flag up anytime you leave the UK or enter the UK. So an arrest warrant will be visible by any passport control. That would then lead to an arrest. And especially if you left the country already, or you're planning on leaving and returning, you would be held by the border control, and they would probably take you to custody, and it would probably be a day or so, day or 2, and they would have you get in front of their magistrates, where you would kind of state your case, and they would probably give you another set of bail conditions. That's my guess. And yeah, that's probably the worst that could happen.
Okay, thank you for that. Then there's so I know this is police bail, right? But with the injunction that was put in place, that was high court injunction, right? So does that affect us in any, extra negative ways at all?
So high court injunctions, civil, so that's high court injunctions are in like the civil realm of law, and then any criminal charges are in the criminal. Those 2 don't communicate all that well, which is good. So technically, whatever is happening in the criminal thing, and you get charged, you police bail and whatnot, that won't really have anything to do with the civil injunction. However, what the civil injunction can do is that at the end of all, when the injunction kind of becomes not relevant anymore, and they go for like the closure of that whole claim, they may want to get all the costs that were attached to this injunction from its making, from its dissemination with people, and all the legal costs behind it, all the court costs and so on. That sum is normally quite eye-watering, and they may try and like hold that on one person. They wouldn't go for it, but they'd just be like, oh, if you take part in animal rebellion, the courts could come for you for £750,000. So that scares people off, and that's what they usually try and do. So they could do that. And obviously for traveling or for leaving the country and coming in the country, that could be flagged with any sort of visas or passports and so on. For them to actually do anything with the civil court injunction, I doubt anything really will happen. we haven't seen much action with civil injunctions from companies, which is surprising because they have the money to do something. But I think they're just really trying to scare people off with the idea of this injunction existing. That's mostly what they do with these injunctions. And did that answer your question, or did I just go on another?
Yeah, that's fine. Thank you so much. And then the last one is probably very quick. Have there been, like, this is related to the raids that have been happening. Have there been any cases whatsoever of the police possibly placing either microphones or cameras in the houses after having done a raid, even though they, for example, let's say it wasn't even legal, they didn't have the right to do it, they still might do it. Do we know anything about that?
We don't know that has happened, placing microphones or cameras or anything. Normally what we've seen is, for example, bunch of Just Stop Oil activists, they got charged because of phone data, and the evidence that there was to charge them was all phone data and apparently phone calls that were recorded. So there is something that they've gotten access to, but it wasn't from anyone's house. So I wouldn't be too worried about that, because I think if that came public, that the police planted cameras into someone's living quarters, I think it would be quite an outrage. And I think the media would love that and the state wouldn't. So I wouldn't be too worried about like cameras and microphones and stuff. I'd be more worried about you using your tech in a not safe way. That's what I'd be focusing on.
Thank you.
Great, thanks. Then Douglas.
Yeah, it was about curfews being enforced. So some of us had a curfew between 7 p.m. and 7 a.m. And mine was at a correspondence address that I gave, so I'm not there. So currently, every time they've checked, I'm breaking bail. And my question was, if that would get overturned by lawyers, would then that qualify as not having broken police bail, or would I have already done it? Would I have already broken it because at the time that's what the bail was?
Yeah, you would have already done it because at the time that's what the bail was. However, if it got overturned, they would probably not do anything with the fact that the bail had been breached. And again, if it's police bail, it's not an actual criminal offense to breach that. So it's they would flag it, and they would probably just, as I said, like have the CPS build a case being like, non-compliant, lied to the police, blah, 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 blah. Not a good character. They'd kind of try and build a case from that, which is, dumb, but yeah, but it's not itself a criminal offense. Yeah.
And they have no fixed abode in the UK, but I do have a correspondence address, and they refuse to put no fixed on anybody's records. So will all the letters and everything be sent to that address? And is there any way to I don't know. It's a major problem for me because I'm not currently in the country, but that is my address. So everything goes there. If I get court bailed, do I have to then live with my parents at my correspondence address, or is there a way to work around that?
You can, for any court bail, you are allowed to give another address when you've actually when they kind of put any sort of bail, or if you're tagged, or for example, you have the chance to give another address. You can also email the police force to change that address as well. So if you want to do it for the letters and stuff, you can do that. A lot of the times I've tried to change a few addresses with the police. It takes a few emails and a few phone calls. So yeah, they're not that good with their admin, but yeah.
Thanks.
No worries. So then SS.
Hi, thanks again for coming in and clearing so much of doubts. But there's one question about visas and immigration. Do they? So that wasn't really, that didn't really clear my doubts. So once it's flagged, only then will it be seen by the HM, or will they be able to just check it regardless? Like when they review our applications, can they just go through those databases and check if we've been arrested or charged?
So arrest won't be seen by the Home Office for visas. It's if you have a conviction. So basically, it's like, you know, until proven guilty or innocent, sort of an idea. So if it's just an arrest, that won't have any effect on your ability to get a visa or your ability to leave or arrive into the country. It's your convictions. And then with convictions, there's an idea of unspent and spent convictions. So spent convictions would be ones that kind of like expire. So lower level offenses and you know, ones that you only got a fine for, and then the unspent ones would be ones that will be always visible. So if you got a prison sentence, or if it was violent or sexual or related to drugs, so those ones won't expire and they'll always be there. And yeah, so from just arrest, that itself won't have an effect on your visas. But it's after that when you actually go through whatever like court process and so on, that would then maybe be visible, maybe not. What the current rule is like for any sort of visas is that if any sort of conviction affects your ability to fulfill all the conditions of your visa, then you would end up losing your visa. So for example, if you're here on a student visa and you get convicted and your university is like, well, we don't want to have anyone who's a convicted aggravated activist, what they want to call us now, then you would lose your place of study. And that would mean you can't fulfill the conditions of your visa. You would be denied entry or you'd have to leave. So that's more where it would come down in visas.
Right. Yeah. So arrests won't be accessible. Is it not accessible, or like will they?
Yeah. So arrest only if the chief police officer would flag them. So if it was a very problematic arrest, so usually this would be like an arrest where you punched the officer or you were really violent, then they would flag it already before any court proceedings. But protest arrest, I've never heard a protest arrest being flagged, so I wouldn't be too worried. I'm an immigrant with about 6 arrests and never had a problem. So, and I you know, travel around Europe and it's fine.
Yeah, thank you.
Great, thank you. Anna.
Thanks, Lex, for all the information. It's really useful. I've got a couple of questions about they're both linked and related to like work and like fitting all this stuff around my job. I have a full-time job. I wanted to ask about whether there's anything you could say about roughly how long it would be, you know, say between a charging decision and a court day. I know that's, you know, not an exact time, but and also whether there might at any point further down the line be a point at which we could start to make a kind of like determination or like a better guess of whether like a custodial sentence would be likely or not. I'm kind of hoping that that's not the most likely, but it probably depends what actions you're involved in, maybe, or maybe it doesn't. But you know, I have a job that runs out at a certain point, and then I have to try and get another. I'm trying to think about like when all this stuff will be happening.
Yes, that's a good question, which I didn't really cover. So the timeline from arrest to then getting charged, that I would say it's from like 3 months to 6 months. Oh. That's like from your arrest to actually getting a letter that you're charged. That's usually it.
Okay.
Sorry.
Bless you.
But the difference is obviously if you were bailed and then in that 28 days, you're then charged at the end of it. From getting charged, usually your plea hearing is in, oh my goodness. Sorry. Usually your plea hearing will be in about 2 to 3 months from that letter. And then depending on which court this would go to, so your plea hearing would always be at the magistrates. And then from the magistrates, if you're going to plead not guilty, and it will stay in the magistrates, so a lower level offence, it would be from about, the wait time is now getting longer and longer. It would be about 4 months to 8 months is the trial date between that. Then if you're going to
magistrate, is that for magistrates? Right.
Yeah, that's for magistrates. So from actually getting charged to where your trial is, I would say that would be 6 months.
Okay. And for those of us that have been police bailed, will we definitely get a charging decision after 28 days? Or
yes.
Yeah.
So they'll have to decide then if they're gonna charge you or if they're gonna release you without further action.
Okay.
And then if you're actually then gonna go to a Crown Court, so which these would be, for example, if it was criminal damage over £5,000 or if it was public nuisance. And these are either way. So you can, the judge would ask you at your plea hearing, would you like your trial to be at a Crown Court or a magistrate's? If you choose Crown Court, the wait time is about a year. And it is getting longer and longer by the day because there's such a backlog of cases. Funnily enough, they are like not having murder cases and rape cases handled, but they keep pushing protest cases into the courts. Think of that what you will, but I think it's quite wrong. Anyways, so basically your Crown Court trial, yeah, I'd say a year's wait at least. So for Insulet Britain, which was, in 2021, so it was a year ago when it started, the first magistrates trials happened just earlier this month, and we've got the first Crown Court trials next February, and then I think most of them are in December 2023.
Oh, wow.
So,
okay, just quite a long time.
Yeah, so that's for Insulet Britain, that happened in 2021. So it's pretty much 2 years from when they actually took action to when the trial is. And
is there anything you can say about, like, how likely, I guess it really depends on the nature of the thing, but will there be a point further down the line? Because I'm thinking I don't want to be like dismissed from my job. So I guess at a certain point, if it started to look like I take it as I don't want to sort of disturb or stress anyone out, but I want to sort of think about, I guess that's a possibility I need to think about. Would there be a point at which, further down the line, we'll have more information about what, about their case against us or anything else? Or is it kind of all just like a big toss up, like, and we're never really gonna be able to say?
Yes, so you would get a big bundle which has all the evidence against you and all the dismissed evidence as well. And this will basically, you'll get all the witness statements and all of that information, and you can build your case against that. So you can, highlight if there are, discrepancies in the witness statements, or, actually this police officer didn't actually do this when they arrested me, and so on. So all of this, you will get all this information. They're not all that good with sending it out. So there are people who've actually gotten it a day before their trial and tried to kind of point out how crap that is. If it's a Crown Court trial, then there's something called a trial management hearing, which would be about 6 months or 7 months before your actual trial. And at that point, they would make sure that you have all the papers. So by that point, you can, lawyers could kind of give you an estimate of exactly what kind of penalties you would be looking at. But I will also say that lawyers also kind of like to say the worst case possible as well. So whatever happens and is not the worst case is just a win for everyone. So just bear that in mind when lawyers give you their estimates, that they will always kind of highlight the worst case possible.
Okay, I understand. Yeah, thank you.
Yeah, great. I think I had, there was one question in the chat, which was, can you negotiate bail conditions prior to accepting and signing for them? And can you refuse to accept them? You can negotiate, and you can't refuse completely to accept all bail conditions. If they're going to give you bail, they will give you bail, no matter if you're going to sign them or not. They would just mark it as you're being non-compliant in the procedure. But you can negotiate bail conditions prior to accepting them. But be aware that the police officer, they can also go make them worse if you're negotiating. But for example, if your bail conditions are going to limit your ability to work, they are not allowed to do that. So you can, especially in those kind of situations, I would negotiate the conditions. But yeah, I hope that helped. Any other questions before we do a nice little grounding? Great. I think everyone's just silenced and overwhelmed. So yeah, I just want to say, like, thank you. One more question. Okay, Tequila.
Yeah, so we're just actually discussing in our group chat. When we were arrested at one point, one of the solicitors told me and some other people as well that it might be better if, and this is again regarding the bail, like the meeting at the police station, that it might be better for the solicitor to handle that for us. What can we do about that? Like, is that a good idea? Should we just get in touch with them and have them handle it?
Yes. So a solicitor can definitely handle the bail meeting as well. That basically, you will have to pay for that because that isn't covered by legal aid. So that would be, unfortunately, like out of your own pocket kind of thing. But that is definitely a way of going about it. But yeah, if that was all, yes, I just want to just thank you all, because you're amazing, and thank you so much for stepping up to take part in such an amazing campaign. It really means a lot to be able to support you guys. And yeah, I'm not getting teary, I'm just snotty, or maybe I am getting teary, but yeah, thank you everyone. Toby's going to do a little grounding, just because I understand that a lot of this is quite overwhelming, and it can seem really scary and all of that, but just know, like, I'm here, CASP is here, we've got our legal support hotline, so if you're having a wobble and you just need to talk to someone on the phone, you can always call that. We have our email, casplegal@protonmail.com. I'll post all of this in the chat in just a little bit, and yeah, just be in touch. We've also got a form for filling out any arrest or charges or any court dates that are coming up. And if you fill those forms, soon we'll have an app as well to do it with, so you can have an app with your own little profile. Don't worry, it's all like very tech secure. We've got a coder doing it. Don't tear up, or do tear up. Tearing up is good. It's good to cry. But yeah, so share all what's going on in that legal realm. and we can be there to support you. We can have group Zooms. We can make sure that everyone who wants representation gets representation, and everyone who just wants a chat and a cuddle gets a chat and a cuddle, even if it's online. But yeah, thank you, everyone. And to you, Toby, to do a little grounding just to finish us off.
Wow. Thank you so, so much. I mean, there's not much we can really say apart from thank you, bless you for everything you do and everything you are. And your kindness just shines and resonates through this weird internet crap that we're dealing with, this weird shit. I don't know what's going on, it's weird. But it comes through and it's beautiful. So thank you so much. I'll stop recording now, if that's cool with everyone. And thank you all for accepting that. This will be available at some point. I'll pass it on to the relevant people and they'll share it with you all. So bless you all.